The first time I saw my company named in the wrongful termination lawsuit, I thought I was looking at an ordinary business problem. Painful, expensive, stressful, but ordinary. My name is Clara Beaumont, and for years I believed my friendship with Adrian Patel was one of the safest parts of my life. A former employee named Kelly Mercer claimed she had been pushed out after raising concerns about favoritism and retaliation inside my management team. I barely remembered Kelly beyond a few performance meetings and one awkward exit interview, so when my attorney first summarized the complaint, I listened with the calm focus I had learned to use whenever something threatened the company I had built. Then, halfway through what was supposed to be a routine case review, my attorney paused on a detail that changed everything. She said the plaintiff's spouse worked at the same law firm representing her. At first, that sounded like a conflict inside the plaintiff's own household, not mine. Then she gave me the spouse's name. Adrian Patel, my best friend's husband, a man who had sat at my dinner table, stayed in my guest room, toasted my company's milestones, listened while I vented about staff issues over wine, and apparently learned enough about my business to help build a lawsuit against it. Naomi and I met in our late 20s at a Women Founders networking dinner in Seattle, back when I was still running Beaumont Harbor Solutions from a rented office above a bakery, and she was managing operations for a nonprofit that served immigrant families. We were different in temperament but matched in loyalty. I was structured, careful, always trying to anticipate the next problem. Naomi was warm, direct, and able to make any room feel less sharp. When she married Adrian, an employment attorney with a polished voice and a habit of asking thoughtful questions, I folded him naturally into my circle. He became the husband of my closest friend, then a friend in his own right, then someone I trusted without examining why. That was my mistake, or at least one of them. Adrian worked at Ralston Greer, a respected employment law firm that handled both employee-side and employer-side matters. I knew the general shape of his work. He defended workers who had been mistreated, advised companies on policy, and occasionally appeared in local business articles about workplace accountability. I respected that. I had built my company from 12 employees to almost 90, and I knew that growth could create blind spots. I was not afraid of being challenged when I was wrong. But I never imagined that the casual conversations Adrian and I had over years of dinners, vacations, holiday parties, and long late-night kitchen talks would be quietly sorted in his mind as potential evidence. I did not know that when I complained about a department head who handled criticism badly, or laughed tiredly about how our promotion process had outgrown its original informal style, or admitted that I sometimes regretted keeping certain early employees in roles too long, I was giving him a map. The lawsuit landed on a Tuesday morning in March. I remember the weather because the rain had been tapping against the conference room windows all through our leadership meeting, and I was thinking about whether the parking lot drains needed repair when my assistant knocked and handed me a sealed envelope. Legal service is rarely dramatic in real life. No music swells, no one gasps. A person signs for documents, reads the first page, and feels the temperature of the room change. Kelly Mercer v. Beaumont Harbor Solutions. I read the caption twice before I looked up. My chief operating officer, Denise, saw my face and asked if something had happened. I told everyone we would resume the meeting later. In my office, with the door shut, I called our outside counsel, Martin Sloan, who had handled contracts and employment questions for us for years. Martin was steady, not easily rattled. He told me to send the complaint over and not discuss the case with anyone beyond necessary executives. By late afternoon, he called back with a preliminary read. Kelly claimed she had been terminated after objecting to what she described as gendered favoritism in operations, inconsistent discipline, and a culture where senior managers protected friends. The complaint sought lost wages, emotional distress damages, punitive damages, and attorney fees. It was serious, but not catastrophic on its face. Martin said we had documentation showing Kelly had missed repeated deadlines, ignored client escalation procedures, and received 2 formal warnings. He thought the claim had weaknesses. I slept poorly anyway. Any lawsuit against a company you founded feels personal, even when you know you must treat it professionally. The next week, we gathered documents, HR files, emails, performance reviews, Slack exports, calendar notes. Kelly had worked for us for 14 months as an implementation coordinator. She was smart but disorganized, friendly with clients but difficult with internal deadlines. Her manager, Rachel, had recommended a performance improvement plan after 3 missed rollout schedules, and Kelly had resigned before the plan ended. That was the first factual issue. She had not technically been fired. She had resigned after being told her position would be reviewed if the performance issues continued. Martin said plaintiffs often frame constructive termination broadly, but he still seemed confident. Then he mentioned the law firm. Ralston Greer. I knew the name before, I knew why my chest tightened. Adrian's firm. I asked Martin, who had signed the complaint. He said the lead attorney was a woman named Danielle Frost. I exhaled. Danielle was not Adrian. That mattered, I told myself. Big firms had many lawyers. Adrian could work there without touching the case. Martin kept reading through his notes and said, almost casually, that Kelly Mercer's husband was also listed in the preliminary disclosure as a firm employee, though not counsel of record. He had noticed it because the surname Mercer appeared in one place and Patel in another, and the conflict form included a spouse relationship. The spouse is Adrian Patel, Martin said. For a moment, I forgot how to answer. I stared at the framed photograph on my shelf from Naomi's 40th birthday, the two of us laughing under string lights in her backyard while Adrian stood behind us holding a cake knife like a microphone. I asked Martin to repeat the name. He did. I said Adrian Patel was married to my best friend. Martin went quiet in the way lawyers do when a social fact suddenly becomes legally relevant. He asked if I had ever discussed company matters with Adrian. I nearly laughed because the question was too small for the truth. Had I discussed company matters with him? I had discussed them in the loose human way people do with friends. Not confidential strategy documents, not payroll spreadsheets, not privileged legal advice, but culture, personalities, growing pains, weaknesses, frustrations. Enough that my stomach began to turn. I told Martin I needed time to think. He warned me not to confront anyone yet. I agreed, partly because I was too stunned to do it. That night Naomi texted me a photo of the soup she had made, joking that I was still forbidden from claiming I did not like lentils. I stared at the message for 10 minutes. My thumb hovered over the screen. I wanted to ask, does Adrian know his firm is suing me? I wanted to ask, do you know? Instead I wrote, looks amazing. Long day here. She replied with a heart and told me to rest. I did not rest. I lay awake replaying conversations. A summer weekend on Whidbey Island where Adrian asked how my leadership team was adjusting after we promoted Denise to COO. A New Year's Eve dinner where I admitted our old disciplinary process had been too informal before we hired a real HR director. A barbecue where I told Naomi, with Adrian listening from the kitchen island, that Kelly Mercer was talented but unpredictable and that Rachel was losing patience. At the time, these were pieces of ordinary life. Founders talk too much sometimes, because the company is always in the room with them. I had never treated Adrian like opposing counsel. He had never given me reason to. Over the next few days, I forced myself not to spiral. Adrian was an attorney at the firm, but that did not prove he was involved. Kelly's husband might work there in a non-attorney role, or the spouse note might be administrative. Danielle Frost might have taken the case independently. Ralston Greer might have screened Adrian off entirely. I wanted to believe every innocent explanation because the alternative felt like a betrayal so intimate it was almost embarrassing. Still, I needed answers from someone who had no loyalty to Adrian's firm and no social tie to my life. Martin was competent, but he had already been our company counsel for years, and I needed a second perspective sharpened specifically around ethics and disqualification. That was how I found Priscilla Nakamura. Priscilla had been recommended by a board member who described her as precise, unsentimental, and impossible to charm. Her office was downtown, high enough above the street that traffic looked silent through the glass. She listened while I explained the lawsuit, Adrian, Naomi, the years of friendship, and my fear that social conversations had turned into legal ammunition. She did not interrupt except to ask dates. When I finished, she tapped her pen once and said, "Do not accuse anyone until the filings tell us what they know." I asked what she meant. She explained that outside counsel can learn many things through client interviews, public records, ordinary discovery, and workplace witnesses. The question was not whether the complaint contained ugly allegations. The question was whether it contained internal details. Kelly could not reasonably know, and the firm could not properly have obtained. Priscilla asked for every filing, every demand letter, and a list of every substantial conversation I remembered having with Adrian or Naomi about company operations. The list alone took 2 days. I felt ridiculous writing it at first, as if I were turning friendship into evidence. Dinner at Cascadia Grill, June. Discussion about Rachel's management style. Lake Chillin rental, August. Comment about informal promotions before HR restructuring. Naomi's backyard, October. Adrian asked about whether early hires still had too much influence. My apartment, January. I mentioned Kelly's missed client deadlines and Denise's frustration. Each entry made me feel colder. It was not that I had disclosed trade secrets, it was that I had trusted the room. Priscilla reviewed the complaint line by line. She called me on a Friday evening and asked whether I was sitting down. The complaint did not merely accuse us of broad unfairness. It described a founder-centered culture where personal loyalty to early employees influenced disciplinary outcomes. It claimed Rachel had been shielded because senior leadership viewed her as essential substantial to the company's origin story. It referred to our pre-HR era and alleged that older informal practices still shaped current decisions despite newer written policies. Those phrases hit me because they sounded like me. Not exactly, but close enough that I recognized the bones. I had once told Adrian that Rachel was hard to manage because she had helped keep the company alive in the first 2 years. I had once joked that Beaumont Harbor had a pre-HR era, back when our employee handbook was 3 Google Docs and a prayer. The complaints language was more formal, but the ideas were not public. They were not in employee files. They were not in policy documents. Kelly had not been at the company during the early years. Priscilla said, "This does not prove improper use by itself, but it gives us a real issue." I asked what came next. She recommended a private investigator named Marisol Vance, a former litigation paralegal who specialized in tracing information sources in civil disputes. Marisol did not look like my idea of an investigator. She wore simple suits, carried a battered leather notebook, and spoke with careful patience. Her job was not to follow Adrian around or dig through anyone's trash. She reviewed public filings, court submissions, correspondence, deposition notices, metadata where available, and eventually discovery materials as they came in. Priscilla also sent a preservation letter demanding that Ralston Greer preserve internal communications, notes, conflict checks, and case intake records connected to Kelly Mercer's claim. Martin remained involved for the company's main defense, but Priscilla took the lead on the potential ethics issue. I entered the strangest season of my adult life. Publicly, nothing had changed. Privately, every friendly interaction felt like walking on glass. Naomi still called me on Sunday mornings. Adrian still appeared in group texts about dinner plans. Miles from our hiking group asked if everyone was free for a weekend trip, and Adrian responded with a joke about needing to escape his caseload. I stared at that message until my eyes hurt. His caseload. Was I part of it? Was my company something he discussed at home after Naomi went to bed? Or was he genuinely screened off, unaware that Danielle Frost had built a complaint using language that sounded like it came from my own mouth? One Wednesday, Naomi invited me over for dinner. I almost declined, but Priscilla advised me not to behave abruptly unless I could not tolerate the situation. "You are allowed to maintain normal contact," she said. "Just do not discuss the company or the case." So I went. Adrian was not there when I arrived. Naomi hugged me in the entryway and said he was stuck at the office on a demanding employment matter. I remember the smell of garlic and ginger in the kitchen, the low music playing, the normal warmth of her home. I sat at her counter and watched her chop scallions while she told me about her mother's knee surgery and a difficult grant application at work. My face hurt from holding itself still. At one point she asked, gently, if everything was all right with me. I said the company had been stressful. She reached across the counter and squeezed my hand. "You carry too much alone, Clara," she said. I almost broke then, because that was Naomi, that was the friend I loved. I could not reconcile her kindness with the possibility that her husband had turned our friendship into a strategy session. Adrian came home after 9, loosened his tie, and smiled when he saw me. "Clara, good to see you." "Sorry. Brutal week." I said I understood. He asked how business was. The question landed like a trap, though it might have been habit. I answered, busy, but steady, and changed the subject to Naomi's dog. He held my gaze for half a second longer than usual. Maybe I imagined it. Suspicion makes an editor of memory. It cuts ordinary moments into evidence. Over the next month, discovery moved slowly. Kelly's side demanded a huge set of internal documents and proposed mediation early, with a settlement number so inflated that Denise nearly dropped her coffee when Martin read it aloud. 7 figures. Not just compensation, not just fees. A pressure number. The demand letter attached a narrative that again leaned heavily on internal culture claims. It stated that Beaumont Harbor's leadership had privately acknowledged ongoing inconsistency in discipline, and that Kelly's treatment was part of a known pattern. Priscilla circled the word privately and read. "Known to whom?" she asked. "We produced documents showing Kelly's performance issues. We also produced written policies, HR memos, and promotion records. Nothing supported a pattern of retaliation. But the plaintiff's narrative had texture, and texture can be dangerous in litigation. It makes a weak case feel human. It gives a mediator something to pressure you with. Pay to avoid risk. Pay to avoid publicity. Pay because juries dislike imperfect companies." I understood the logic, but I also understood something else. Someone had given the case that texture. Marisol's first significant update came through a memorandum that Priscilla sent under privilege. Ralston Greer's initial disclosures listed Danielle Frost as lead counsel, an associate named Owen Briggs, and, unexpectedly, Adrian Patel as consulting attorney for intake and employment practices context. My hands went numb when I read that. Consulting attorney, not screened off, not uninvolved. Priscilla said we needed more before filing anything, but the issue had sharpened. Adrian had not signed pleadings, yet he had participated in shaping the case at intake. That meant he had touched the matter while knowing, or while easily able to know, that the defendant was my company. It also meant his social relationship with me was no minor coincidence. I asked whether this was automatically illegal. Priscilla said no. Lawyers are allowed to represent clients against people they know socially unless a specific conflict, confidentiality breach, or improper information use exists. But if Adrian used information obtained through a personal relationship, especially information he knew was shared outside any adversarial context, the court could disqualify the firm. There might also be bar consequences, but that was separate. I wanted to call Naomi immediately. I wanted to ask whether she knew Adrian had been listed as consulting attorney. Priscilla told me to wait. If Naomi does not know, you will detonate her marriage without giving her anything solid. If she does know, you will warn them before we have the record. I hated that she was right. I began keeping my own notes after every interaction. Naomi texted, asking if I wanted to join her for yoga. Adrian emailed a group about restaurant reservations. At a birthday gathering for a mutual friend, Adrian kissed Naomi on the temple while she laughed at something across the table, and I felt an ache I could not name. Betrayal is not clean when it passes through people you still love. I did not want to punish Naomi for her husband's choices, but I could not stop wondering what conversations happened in their home. Did she mention things I had told her? Did Adrian ask questions casually, the way he had asked me? Did he understand exactly what he was collecting? Marisol found the next piece through discovery after Priscilla pushed for intake notes related to the complaint's factual basis. Ralston Greer resisted, claiming work product protection. Priscilla narrowed the request to non-privileged source identification and conflict materials. The court ordered limited production. What came back was heavily redacted, but not useless. In one intake summary, Danielle Frost wrote that AP has independent familiarity with defendant's leadership culture through long-standing social relationship with founder. In another note, Owen Briggs listed potential themes: founder loyalty, early employee protection, informal HR history, Rachel problem, inconsistent discipline. Beside two of those themes appeared initials: AP, Adrian Patel. I read those words in Priscilla's conference room with the blinds half closed against the afternoon sun. For several seconds, I could hear only the air conditioning. Priscilla asked if I recognized the phrase Rachel problem. I did. I had used it once at Naomi's dining table after Adrian asked why I seemed distracted. I had said, "It's the Rachel problem again. Brilliant with clients, terrible with feedback, and too tied to our early survival for anyone to handle cleanly." Kelly Mercer would not have known that phrase. It had never appeared in an email. It was not in Rachel's file. It was not in any HR document. It was something I had said in exhaustion to friends. Marisol's final report connected several complaint themes to specific social conversations I remembered, and in two cases, to calendar events where Adrian had been present shortly before Ralston Greer's internal notes recorded similar wording. It was not a smoking gun in the movie sense. There was no email saying, "I learned this from Clara over dinner, let's use it." Real life rarely offers that. But the pattern was strong. Adrian's notes gave Danielle the architecture for a case that otherwise would have rested mostly on Kelly's disputed performance history. He had taken observations gathered from my friendship, filtered them through his professional expertise, and handed them to his firm as context. That was enough for Priscilla to act. Before she filed the motion, I told Miles from the hiking group that I needed to step back from social plans for a while. I told Denise only what she needed to know, that we had grounds to challenge opposing counsel due to improper use of personal information. I did not tell the entire leadership team because Rachel's name was already tangled in the narrative, and I refused to let office speculation become another wound. Then I called Naomi. My hands shook so badly I had to set the phone on speaker and place it on my desk. When she answered, she sounded cheerful and distracted. "Hey, stranger, I was just thinking about you," I said. "Naomi, I need to talk to you in person. It is serious, and it involves Adrian." Silence. Then a small, careful, "Is he okay?" That question told me enough to keep going gently. I said he was physically fine, but I needed to discuss something legal and personal. She came to my house that evening. I had printed nothing because Priscilla told me not to distribute documents casually, but I had permission to explain the general facts. Naomi sat on my sofa with her coat still on, her face pale before I started. I told her my company had been sued by a former employee. She nodded. She had not known. I told her Ralston Greer represented the plaintiff. Her eyes flickered. She knew Adrian's firm, obviously, but the connection had not landed yet. Then I said Adrian had been listed as a consulting attorney on the case. She stared at me. No, she said. Not a denial exactly, more like a refusal from the body. I explained that filings and case notes suggested he had provided context about my company's internal culture, including details he could only have known through our social relationship. Naomi stood up, walked to my kitchen window, and pressed her fingers to her mouth. I expected her to defend him. I expected anger, or suspicion that I was exaggerating to avoid responsibility in the lawsuit. Instead, she whispered, "He asked me so many questions." My stomach dropped. She turned around with tears in her eyes and said Adrian had occasionally asked about how I was doing, whether work was still tense, whether Rachel was still difficult, whether Denise had managed to formalize HR. Naomi had thought he was being interested because I was her best friend. She had shared things in the harmless way spouses share ordinary life. She had no idea there was a case. "Clara, I swear to you, I did not know," she said. I believed her, and believing her almost made it worse. Because now the betrayal had widened. Adrian had not only used me, he had used his wife as another channel. I told Naomi I was not asking her to choose sides that night, but Priscilla would be filing a motion, and the facts would become formal. Naomi asked if I hated her. I said no. I said I was hurt and frightened and angry, but I did not hate her. She cried then, not loudly, but with the exhausted grief of someone watching the floor disappear beneath her marriage. When she left, she hugged me carefully, as if both of us were injured. The next day, I met Adrian face to face. Not alone, because Priscilla insisted. We arranged it in her office with Naomi present at her request. Adrian arrived in a navy suit, composed but drawn. He greeted Priscilla politely, then looked at me and said, "Clara, I can explain." I said, "Then explain why your initials are beside themes in a lawsuit against my company that came from private conversations in my home." His jaw tightened. He said he had never disclosed privileged information because I had never been his client. Priscilla cut in and said the issue was not attorney-client privilege alone. It was improper acquisition and use of personal information obtained through a relationship of trust, plus failure to address a conflict created by his close social connection with the defendant's founder. Adrian said Kelly had legitimate claims and that workplace culture mattered. I said, "Kelly may tell whatever truth she has. You did not need my friendship to help her do that." That was the first time his composure cracked. He looked at Naomi, but she did not rescue him. She asked, "Did you know Clara was the defendant when you helped with intake?" He hesitated just long enough. Then he said yes. Naomi closed her eyes. Adrian tried to frame it as a professional judgment. He said he had general knowledge, not confidential documents. He said he believed my company had cultural issues that could harm employees. He said he had not meant to make it personal. I felt heat rise in my face. "You came to my house after the complaint was filed and asked me how business was," I said. "Was that professional judgment too?" He had no answer. Priscilla ended the meeting before emotion could outrun usefulness. She told Adrian all further communication would go through counsel. Naomi left separately from him. I watched that from the conference room window and understood that whatever happened in court, something private had already broken. Priscilla filed the motion to disqualify Ralston Greer 2 weeks later. It was careful, not theatrical. It cited Adrian's long-standing personal relationship with me through Naomi, his participation as consulting attorney, the firm's use of internal cultural information not publicly available and not apparently derived from legitimate discovery, and the risk that continued representation would undermine the fairness of proceedings. Martin supported the motion with declarations about what company records did and did not contain. I submitted a declaration listing specific social conversations, dates, and topics. Writing it felt like dismantling years of friendship into numbered paragraphs. Naomi submitted her own declaration voluntarily, stating that Adrian had asked her questions about my work, and that she had not known those questions related to litigation. That cost her. I knew it did, and I did not forget it. Ralston Greer fought hard. Their opposition argued that Adrian's knowledge was general, that social conversations are not confidential in the legal sense, that Kelly's claims stood independently, and that disqualification would unfairly burden the plaintiff. Danielle Frost insisted the complaint was based on Kelly's experiences and witness interviews. Priscilla replied that the issue was not whether Kelly could pursue her claim, but whether this firm could continue after using Adrian's relationship-derived knowledge to sharpen the allegations. At the hearing, the courtroom was smaller than I expected. No jury, no dramatic audience, just lawyers, binders, polished benches, and the judge asking exact questions. Adrian sat behind Danielle. Naomi was not there. I was grateful for that. The judge asked Ralston Greer why Adrian had not been screened from the matter once the defendant was identified. Danielle said his role had been limited. The judge asked why internal notes credited AP with themes matching non-public information. Danielle said attorneys often brainstorm from broad professional knowledge. Priscilla stood and calmly walked through the timeline. Dinner conversations before intake. Adrian's listed role. Complaint phrases matching private statements. Discovery notes identifying his familiarity with my leadership culture. Naomi's declaration. She did not overstate. That made it stronger. When the judge finally ruled, she did not accuse Adrian of every dark intention I had feared. Courts speak in measured language. But she found that the appearance and substance of impropriety were serious enough to disqualify Ralston Greer from representing Kelly Mercer in the matter. She said the integrity of proceedings required that litigation strategy be built through proper channels, not through a lawyer's exploitation of a close personal relationship with an opposing party's principal. Hearing that sentence, I felt my shoulders drop for the first time in months. The lawsuit did not disappear. Kelly had the right to find new counsel, and she did. But without Ralston Greer's original strategy, the case changed. Her new attorney focused more narrowly on her performance plan and resignation. The grand narrative about founder loyalty and hidden cultural rot faded because it could not be supported cleanly. Mediation happened 6 months after the complaint was filed. We settled for a modest amount that was less than the projected cost of continued litigation, with no admission of wrongdoing and a neutral reference. Some people might hear that and think settlement means guilt. It did not. It meant I had a company to run, employees to protect from endless legal distraction, and a board that understood arithmetic. Rachel received management coaching. Denise tightened our documentation standards. We revised our conflict reporting, complaint escalation, and performance review procedures. Not because Kelly's exaggerated lawsuit was right in every respect, but because pressure reveals where systems are too dependent on memory and trust. I could be angry at Adrian and still be honest about my company's growing pains. That distinction mattered to me. Adrian resigned from Ralston Greer before any bar proceeding concluded. I heard that through Priscilla, not Naomi. The firm issued a bland statement about internal review and professional responsibilities. Adrian sent me one letter, through counsel at first, and then forwarded personally after the legal matter closed. It was an apology, though a guarded one. He wrote that he had convinced himself the information he had was merely background, that he believed he was helping a worker tell a fuller story, and that he failed to respect the personal trust through which he had learned those details. He said he was sorry for harming my friendship with Naomi. I read it twice and put it in a drawer. I did not respond. Forgiveness, if it comes, does not always require correspondence. Naomi and Adrian separated for several months. She told me over coffee one gray morning that the worst part was not only what he had done to me, but how easily he had made their marriage part of it. He turned our kitchen into an intake room and I didn't even know, she said. I had no answer that could soften that. Our friendship survived, but it changed shape. For a while, we avoided talking about anything serious. We met for walks instead of dinners. We spoke about her mother, books, weather, recipes, small repairs. Slowly, cautiously, the deeper things returned, but my company did not. I no longer vented about employees over wine. I no longer used friends as a pressure valve for leadership problems. That was healthier in some ways and sadder in others. Trust does not always vanish after betrayal. Sometimes it becomes more formal, more aware of doors and locks. Naomi eventually decided to continue working on her marriage, though she and Adrian moved into counseling and separate finances for a time. I did not ask for details unless she offered them. I also made a boundary. I would not be in social settings with Adrian for the foreseeable future. Naomi accepted that without argument. Almost a year after the lawsuit first arrived, she invited me to her birthday brunch and told me Adrian would not attend because she wanted me there comfortably. That was the moment I knew she understood the cost without making me explain it again. The company recovered. In fact, the experience forced us to mature faster than we might have otherwise. We created clearer rules about what executives could share outside work. We trained managers to document decisions in plain, timely language. We stopped relying on unwritten history to explain why certain people received patience and others did not. Rachel improved, partly because Denise finally stopped treating her early contributions as a shield against accountability. Kelly moved on to another job in Oregon. I wished her no harm. I still believe her case became something larger than her actual experience because Adrian gave it a frame it had not earned. But I also know she was a person, not just a lawsuit, and I hope she found a workplace that fit her better. The hardest lesson was not legal, it was personal. I used to believe betrayal announced itself through malice, through obvious envy or open hostility. Now I know it can arrive wearing the face of professional purpose. Adrian did not have to hate me to hurt me. He only had to decide that his cause, his case, or his cleverness mattered more than the trust that gave him access. He listened as a friend and used what he heard as a lawyer. That is a line you cannot uncross. I still think about one small moment from before all of this. A dinner at Naomi's house when Adrian raised his glass and said he admired what I had built, because few people could grow a company without losing themselves. I smiled then, proud and a little embarrassed. Later, parts of what I shared that night appeared in a complaint designed to make me look careless, hypocritical, and cruel. Maybe both moments were true in his mind. Maybe he admired me and judged me at the same time. That complexity does not excuse him. It only reminds me that people rarely betray you as simply as stories make it sound. If there is anything I would tell another woman building something of her own, it is this: protect your peace, but also protect your information. Friendship can be real and still not be the right container for every fear. Marriage, law, business, loyalty, ambition, all of those worlds overlap more than we want to admit. I am not closed off now, but I am more careful. When I need legal advice, I call my lawyer. When I need executive counsel, I call my board chair. When I need comfort, I call Naomi, and we talk about life without turning my employees into conversation pieces. That boundary was paid for, and I honor it. So what would you have done if your best friend's husband had quietly used years of private conversations to help sue the company you built? Would you have confronted him immediately, waited for evidence, or walked away from the friendship entirely? Share your thoughts, because situations like this are never as clean from the inside as they look from the outside. Thank you for listening to my story. If you want more stories about trust, betrayal, accountability, and women rebuilding their lives after the people closest to them cross the line, subscribe and come back for the next one. Take care of yourself, and be careful who gets to hear the unguarded version of your life.